if Tyler Robinson's defense team or Tyler Robinson's family or Tyler Robinson's GoFundMe group or whoever is in charge of this, if they don't retain Baron Coleman as co-counsel, pro hoc vice, this would be per se legal negligence, legal malpractice, provided they had the opportunity and deliberately refused to do so out of hubris or what have you. It would be the greatest injustice ever. It would be almost like saying you don't even have a defense team. And I will explain to you why. And I will explain to you the absolute, seemingly endless stupidity, ignorance that I'm seeing on the part of so many people who they mean well, but they don't know shit about law. Let me explain this to you in no particular order. Number one, trials are based on fact, not law. That's appellate stuff. The law is going to be there. You're not going to. The judge is going to make sure you don't, have 3 jurors versus 12. The law is going to apply. Yeah. But that's not what gets you an acquittal. It's the facts of the case. And the lawyer that knows the facts wins. Or doesn't take the case or pleads. It's all about fact. Jurors are the triers of fact. The judge is a trier of the law. And in a bench trial where there is no jury, the judge obviously does both. But remember, the jury, whenever you hear this phrase, the trier of fact, the jury decides what evidence is good, how much it weighs, how much attention you should give it. The rules have to be, remember when you ever watch Perry Mason and they would say, objection, incompetent, irrelevant, and immaterial. It's like, oh my God, incompetent? Irrelevant, incompetent. Competency is mostly witnesses, to be competent as a witness. And competency is defined very, very simple under the rules of evidence. Very, very simple. Number one, did the witness that we are seeing, did the witness see, feel, touch, taste, smell, experience that which he or she is intending to testify about? Were you there? Did you smell it? Did you see it? Yeah, I saw it. I saw this bit. Yeah, I saw it. Yeah, I smelled it. I heard it. I heard him say that. I didn't hear him say that. I heard the gunshot. I didn't hear it. I smelled like gunpowder. It smelled like bacon. Yeah, I smelled. It was weird. It was a weird taste. It was a taste of metal. It was whatever it is. Whatever. Mostly it's seeing, but hearing, discussion. But that's it. One. Did they experience it? Number two, do they recall it? I know it sounds crazy. Did you see it? I sure did. You remember it? Nope. Incompetent. You are you do not possess competency to testify. It is that simple. Next. Can you explain, detail, explicate, limn, describe that which you smell, taste, or whatever it is? Yes. Yes. Yeah. If you can't, I don't want to be cruel, but if somebody, let's say, is paralyzed and cannot communicate at all through anyone, through sign language or writing or Stephen Hawking or nothing, but they were there, they remember it, but they can't communicate, it's incompetent. Incompetent. Your competency. And number four, this is the most important thing. Are you under oath? Did you swear to tell the truth? Did you recognize the fact that you know the difference between telling the truth and not telling the truth, between lies and not? And by the way, there is no minimum age or where a person has to be, some juror, like a child has to be 8 years old to testify. This is the witness, by the way. You got to be 8 years old to testify. No. There's nothing. As long as you did what I just told you, as long as you maintain it, that is the most important thing in the world. Because what we're talking about is very simply this. We are talking about very simply the rules of evidence regarding competency. What does competency deal with? It deals with witnesses. And what do you have to have in order to be a competent witness? That's what we're talking about. That's it. That's the first thing. They're the people who try the facts. They're the ones, absolutely. They are it. You understand this? This is the most important thing in the world. Everybody is presumed competent to testify unless there's some specific rule. We're not going to go into this, but I'm going to give you basic, rudimentary. This is nothing but plain old evidence code 101. Okay, you got that? That's all. That's to be a witness. That's it. You have to have seen it. You have to have been there. The only time you don't get to see it, the only time you don't have to be there, the only time you're usually not is when you're an expert witness. And an expert witness is the only person who can give an opinion. See, we hate opinions from jurors. Hate them. I think he was going 58 miles an hour. Objection. What is this, opinion? What are you, an expert? How do you look at something and tell? How do you, what are you talking about? Check this light here. Oh, this light's kind of weird. A little better, sort of. Anyway, so that's it, okay? Okay. There are some exceptions. They're kind of like the collective facts every day. I forget the name of collective facts. For example, when you said, smell like bacon. Okay, we know what bacon is. That's an opinion. That's an opinion. You can kind of guess maybe the time of day, but, just stuff that doesn't require any kind of special thing. So that's the rules. That's the rules of witnesses. That's it. And by the way, remember I mentioned about the minimum age. There was a famous case where this child was taking the stand. I forget what the particular case was, and the judge had to determine whether the child knew the difference between lies and not facts. You don't have to. I've never seen a Bible. You don't have to raise your hand on the Bible. I've never seen a Bible ever. And they asked this one particular child, "Do you know what a promise is?" And she said, "Yes. A promise is like glass. You can't break it." Oh my God! They said, "That's it. That's it. She's in. We win." Okay. And that, my friends, that is the rules of evidence regarding witnesses. That's it. And they are the most important people in the world. They are the most important people in the world. They are it. They are it. The jurors, I should say, who look at the witnesses, who weigh your testimony, they're it. They're it. They don't know anything about competence. They don't know anything about this, about hearsay rule or whatever. They know nothing. They just say, I believe it, I don't believe it. And what is their goal? What is their message? What do they do when they go through all the witnesses? What is it they're trying to figure out? What will get Tyler Robinson acquitted? Innocence? No. Say it. Say it. What is it? Reasonable doubt. I don't care what you say. Reasonable doubt. Now enter Baron Coleman, the genius. An individual who has, I've never seen anything remotely like he does, ever. Even in actual trials going on, federal, state level, it doesn't matter. The disambiguation, the specifics, the dissection of time and who was where and when and how this negates this claim. What does all of this do? Do you think jurors or most of the people who listen to him know every little fact, every little discrepancy? Eddie, any or every little idiosyncratic nuance twixt this and tweet. No! You get the idea that it's not likely for him to be on Discord after he's been arrested and all that kind of stuff. But the point is, what does he do? What does it mean? Reasonable doubt. Ladies and gentlemen of the jury, you've heard the testimony as adduced, as explained by the inimitable, the ineffable, the one, the only, Baron Coleman, counselor, co-counsel, pro hoc vice, meaning you petition the Utah court to let you in for this special appearance. You have some local counsel kind of act, get your mail and stuff, but basically vouch for you. But. So what this means, what all of this means is very simply this. He comes in and he starts throwing charts and graphs and times, and that jury will say, let me out of here. I don't believe anything. Because the doubt that he imparts, the doubt that he creates here, affects everything. And by the way, this is just one thing. If you get the impression, without saying it, that people are lying or negligent or not paying attention. Look, you don't have to say that the police are lying or the prosecution is lying. No, you just say they're wrong or they made a mistake or the facts are not as they seem. Is that the same as lying? No, a little bit, but not really. Not really. See, I can see the following. Ladies and gentlemen, reasonable doubt derails the train. Give me one reasonable doubt as to the guilt, as to the facts as adduced, as presented, as averred by the prosecution. A reasonable doubt as to the guilt of Tyler Robinson, that's not guilty. How much has to be a reasonable doubt? What if they show you 99%, you say, okay, but there's 1% reasonable doubt. Well, if that 1% is critical, that's not guilty. And then again, juries there's a flavor of the case, like it's a dog, it stinks, it sucks, and you never know what happens. My friends, I graduated and later was licensed 43 years ago. I've seen at the trial level stuff that is like, how did this happen? From traffic court to family court to juvenile court to misdemeanor, felony, grand juries, administrative hearings, small claims, that's another story. You name it. When you put human beings and you swear them in and they forget or they're scared or you have a prosecutor, for example, who asks the wrong question, who lets somebody go too long or who says something, you don't know. These witnesses are not scripted. They don't know exactly what they're going to say. They don't know exactly the testimony they're going to give. They really don't know this. They don't know any of this stuff. But what they do know, which is interesting to know, what they do know is that they will tell a story, but they don't know how that piece of testimony comports with the other witness because there's the rule of sequestration. The rule of sequestration is almost always, should be invoked at the beginning of the trial, which says any witness who's going to testify must leave the courtroom. You cannot sit and listen to somebody else's testimony. And then you take the stand and say, yeah, just like he said. So when you go up, you don't know what somebody else said. You don't know anything. You don't know what you're going to do. I don't care if you're a cop. I don't care. You may think nothing about what you've said. And let me also say something, and this is very, 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 very critical. When I spoke to Mr. Coleman, I asked him something to the effect of, would you consider co-counsel, or has anybody asked you, whatever it is. He said, well, if they did, I would tell you, and all this stuff. I have not spoken to him about that. I've not spoken to him since we spoke on my show, and that's it. So I don't know. If that defense team, maybe in the QT, said, Mr. Coleman, yes, my name is so-and-so, I'm an investigator. We spoke on the phone with the Tyler Robinson defense team. Would you mind showing me some of just your timeline? Not as a lawyer, but as somebody who just collects facts. There's a lot of people who come up with some great stuff, some fascinating information. They're not lawyers. They're just, some of the best stuff that ever happened regarding the JFK assassination were not from lawyers, but from amateur historians, people who've never done this in their life. Mr. Coleman, can you show me some, what do you think are important glitches in the timeline? Yeah, I'll show you. And can you show me where you get this from? Not what you think, but where you glean these particular facts. And he'll say, yeah, from here, 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 and here. Thank you for this. That's excellent. Thank you, sir. Very good. Thank you. Thank you for that. Thank you. Thank you. Thank you. And then you say, whoever's on the stand, and you take out your little pen, your pointer, and you say, detective, officer, whatever. What version of the facts do you like? Do you like this fact regarding Tyler Robinson? Do you think that Tyler Robinson, after he was Mirandized and refused, did not testify? And by the way, if he said, I want to speak to a lawyer, and they bring that up, that's a mistrial. So watch that one too. Mistrials are like a minefield. Sometimes cops say they don't even know. I asked him what he said, and he said, I don't want to talk to you right now. I want to talk to my lawyer. Because you're commenting. If you comment, if you refer to a defendant's election to invoke the Fifth Amendment, that is a mistrial. That is a constitutional violation, because you have the right to remain silent, and they can't use it against you later on. They can't say, you know what? They say there's two sides to every story. Well, not with this son of a bitch. I asked him, he wanted to talk, and he said, no, I want to talk to a lawyer. Gee, I wonder what. Maybe if you weren't guilty, you can't because you're intimating them. So that's another glitch. That's another one. Oh my God, a mistrial after all this time. Tee it up again. And defense say, give me all the mistrials you want. Just keep throwing that fly in that ointment. Because don't be surprised if they make some kind of deal with old Tyler, and he figures, you know what? But anyway, we'll talk about that later. Let's don't get ahead of our skis, as the kids say today. Do the kids say that? I don't know. And who are these kids? So I've never talked to Baron, but all he would have to do is say, let me just show you. And by the way, this goes for all the from Nisi to Fredo to Baron to you, to name it, to, of course, Candace, and say, this is what we found. So if you're a juror and you say, I've got 4 different versions of this. They didn't tell me this, but apparently, thanks to some industrious fact finder, deep diver, as it were, this is very interesting, because much to my, not chagrin, but much to my dismay, my fascination, this is most interesting because he is doing things that don't make any sense. You're writing all these times down. When people normally don't want to talk to you, they don't want to talk to anybody. Going online, unless he's just demented, just doesn't make any sense. Just like the 2 versions of his story. Version A, which is what they were going to go with, they thought that Tyler was going to say something to the effect of, I can't live in prison. I can't live without freedom. So, and that would have been maybe the precursor to the big shootout or whatever it is. But that didn't happen. He went to the first one where he said, interesting enough, he said, no, I think I'm going to turn myself in and talk. So that all of the facts were already in line and set in motion for that first version of the confession. And then when it changed, a lot of the facts didn't make any sense. Well, what happened? He didn't go through. He survived. He wasn't supposed to survive. Anyway, we'll see. But if they have not said, Mr. Coleman, what do you feel comfortable with? We will not have you as a. And by the way, if you got to be careful, because if Baron does say this, well, let me turn over what it is, my information, my collation of the facts, then he's a witness. He's like an expert. He's not a witness in terms of seeing something, but he's a witness in terms of having reviewed and collated the facts of the case. I don't even think he needs to even his name doesn't even have to be known. If I'm presenting to you something, if I say, here is the evidence that you have, here is the evidence that I have, it's identical, but my interpretation is different. My interpretation allows a different version of it. I don't even think Baron has to testify to anything, because he didn't see anything. He's just going through the records. He's just going through that which is already there. He's almost like a paralegal. Paralegal doesn't testify. The person who goes through the medical records doesn't testify. They just put them together, collate them, and say, here's what you do. But if they haven't reached out to him or Candace or any of the aforementioned, that is legal malpractice. And that makes me think there's something, this case is rotten. No, I'm not suggesting this. I'm not intimating this. I'm not even hinting that they're trying to throw the case that these are Fed jacketed or whatever the phrase is today. Fed slap jacketed. No, I'm not suggesting that. But what I'm suggesting is that there is so much here that if the jury heard 10% of all of the inconsistencies, they would say, this is a dog. And what happens is it would then have to be the job of the prosecutor to say, no, you don't understand. You don't understand. This is not important. Yeah, there's a mistake. Whenever you are impeaching a witness, and impeaching, we always think about it in terms of the president's sense, but impeachment or the removal from office. Impeachment means to affect the credibility of a witness. Whenever you're impeaching the testimony or the witness of somebody, what you're doing is you are, in effect, diminishing the credibility, and you're showing that they should not be believed, or that their testimony should be given less weight, which is what the trier of fact does. It weighs. It may say, I'm going to give that witness a lot of weight. This one, I'm not even going to listen to. I don't like this person. I think they're there for the money, or it was an old lady who couldn't hear. I don't think she heard the gunshots. I'm not going to. They can reject everything. They can say, I don't believe anybody. It's up to them, and there's nothing you can do. And if they acquit the defendant, that's it. Double jeopardy. You can't try him. He's acquitted. He walks forever. That's it. In state court. Federal court, if it's a different case like they did with OJ. Anyway, not to get ahead of our skis, not to get ahead of the game. But he and others, if they just saw charts and lines and this, and what I want them to have this feeling was, go ahead. Do you feel confident to find this young man guilty? Do you feel confident that the case was proved beyond a reasonable doubt? Do you feel confident? Do you feel from the bottom of your heart that really is the guy, but most importantly, that they proved it? Because here's the thing, too. You may say, look, I know it's him. I know it too, but they didn't prove it. Just because, remember, jurors are not detectives. They may know a lot of things. But if nobody proves it, sorry. Now, one more thing. I have been getting a spate of emails and comments from a lot of people, and I think you know who they are, and I don't want to call them out, but it goes something like this: who are you to think you're some expert when you've got coroners, you've got prosecutors, you've got police, and you're coming along and you're telling us what? That you know what's going on? That you're some genius? This is what they're saying. This is what they're saying. I mean, and you call yourself a lawyer? And Baron calls himself a lawyer? First, they're trolls. Second, I don't know what their motivation is. Are you upset? Do you have this connection with Charlie or against Tyler or not against due process, or what's your beef? It's the troll. They don't like people. They don't like people, especially Baron, getting credit for doing yeoman's work and incredible work. They just don't like it. There are these people who, I swear to God, if you found, remember that little girl? The kid fell into a well, and the kid, they thought it was forever lost in a well, and they rescued the kid in the well. Somebody went to, anyway. These people would say, "Oh, there you go, showing off again." They're miserable. They're miserable. They don't like anybody. They just don't like anybody or anything. And they're jealous, and they just, and I'm thinking to myself, do you know how many cases have been overturned on appeal, convictions reversed, charges dropped, cases dismissed, acquittals, where the prosecution thought at first, we have enough case here. The prosecution had found, not reasonable doubt, but probable cause. They jumped through all of the procedural hoops. They were ready to go. They did all this stuff, and the jury ultimately said, "Forget it. This is a dog," or it was acquitted, or whatever. We can't go every single time that a prosecution says, "Yeah, we have enough here." Since when do we trust the prosecution? Or since when do we say, forget about the adversarial system, forget about the jury system, let the jury decide? It's the strangest thing. So you're going to get these people. Go through the comments, you'll see them. I don't know who these people are, where they're from, but you want me to go? You know what? Don't ever. Okay, if first thing you're going to do when you get a speeding ticket, you want to get out of it, right? You want to test the charges. You want to see if they can prove this. Is this ticket okay? Did they put the right information? Did they put the right intersection? Did they write the particular type or the model and make of the speedometer of the gun? Did they follow? You're going to say, yes, get me out of this. That's exactly what they want. But when it comes to somebody else, they're not interested. It's nonsense. Complete and total, utter nonsense. So that's it, my friend. So as far as Mr. Coleman goes, my friend, you are without peer, as are others. I can go down the list. But his latest review is just superb. Absolutely superb. And I hope that somebody from that defense team is smart enough to say, would you show me what you've collated? Voluntarily do so. That's all. I don't think he'd have to testify. I don't think he's a witness. He's just like he's a paralegal. He's somebody who goes through medical records in personal injury cases. He reviews things. He just does all the work for you. All right, dear friends, thank you. Now, I've got some questions for you coming up, and I want you to go to the comment section and ask them. Please, let me remind you again, I don't want to do it all the time, but I have to. Please like this video. It's important that you like it. Like our video to keep us going. Put us in the HOV lane of awareness and the like. Please hit that little bell so you're notified of live streams and new videos. And if you are not subscribed, please do so. We are coming up on 400,000 and I need every one of your votes. It's a milestone. I can't compete with Candace with 6 million, but I can't get to 6 million unless I get to 400,000. And that's my next goal. And I need your help for that. And I would appreciate it immensely. That's it, my friends. So go through the foregoing and whatever. And also, just remember one thing. Comment as you see fit.